Welcome back to the Deep Dive. We're the place you come to when you need to make sense of, well, the complex stuff. The legislation, the court rulings, the government reports. We sort through it all to bring you what really matters.
And today, we're definitely diving deep. We're tackling the world of Australian data protection. It's a space that's changing fast, getting stricter, and frankly, the consequences for getting it wrong are pretty huge now.
Huge is right.
Yeah.
It's essential listening, really, for anyone doing business here in Australia, or even if you're overseas but dealing with Australian customer data. We've seen a really big wake-up call recently, haven't we? A formal ruling from the Office of the Australian Information Commissioner, that's the OAEC.
Yeah, the privacy watchdog.
Exactly. And they ruled against a major Aussie retailer. And the surprising thing, it was over something that on the surface seems pretty common, security at the returns desk.
That case, the Kmart case, it's really set a new benchmark. It's shown that even routine operations can trip you up badly if you're not handling data correctly under the Privacy Act.
So that's our jumping off point today. We've got the OAIC determination itself. We've got some excellent legal analysis from top firms breaking it down, plus reports on the big law changes coming down the pipeline.
Yep, plenty to get through.
Our mission: use this Kmart situation as a sort of lens. We want to really unpack the Australian privacy principles, the APPs, which are the heart of the law, and demystify some of those key terms you hear thrown around, like sensitive information and reasonable steps. What do they actually mean in practice?
And this isn't just theory. This is about actionable intelligence. We're not just going to read the act to you. We want you to understand the why these rules matter and how they apply in the real world.
By the end of this, you should have a much clearer picture, not just of the black letter law in the Privacy Act 1988, but crucially, the much higher standard of accountability that's now expected. It's about ethical data handling, really.
It really is. It's a shift in thinking.
Okay, let's get into it then. Let's start with the specifics of that Kmart case. How exactly did a big-name retailer find themselves on the wrong side of the privacy regulator?
Right. So the OAIC's determination against Kmart Australia Limited, it's quite recent and it's pretty significant. It focused specifically on their use of facial recognition technology, FRT.
FRT.
They used it in 28 of their stores over a couple of years, roughly between June 2020 and July 2022. And it's really important context here. This wasn't the first time the OAIC had looked at FRT in retail.
Ah, right. There was the Bunnings situation before this.
Exactly. Bunnings got pulled up for similar practices. So the fact that Kmart went ahead or continued with their system after that precedent, well, it makes this ruling even more pointed. It shows the OAIC is serious and consistent on this issue.
Okay, so let's be clear about the tech itself. This wasn't just like standard CCTV footage we see everywhere.
No. Much more specific. It was deployed only at the returns counters inside the stores, and its stated purpose was very narrow: loss prevention. Specifically, detecting and preventing fraudulent refunds.
How did it actually work then? What happened when someone went to return an item?
Okay, so when any customer approached the returns counter, it didn't matter if they'd done anything wrong before or not, the system captured their facial image.
Every single person?
Every single person.
Wow.
Then the system processed that image. It converted the unique geometry of their face, the distances between eyes, nose, mouth, that sort of thing, into a digital template, a unique biometric identifier.
So it's creating new data, a sort of face print?
Precisely. That's the key bit. It creates this template, which is metadata, and then it compared that template against a database Kmart maintained. This database contained the templates of individuals who'd previously been flagged by Kmart staff for suspected theft or refund fraud.
Right, a blacklist, essentially.
Yeah, you could call it that. If the system found a match between the customer currently at the counter and a template already in that database,
an alert goes off.
Basically, yes. Staff would be alerted, and they were then empowered to refuse the refund or the transaction based on that match.
Okay, so from Kmart's perspective, you can see the logic. Refund fraud costs retailers millions. They likely thought, we need to stop this. What was their actual legal defense? How did they argue this was allowed under the Privacy Act?
They tried to rely on a specific exemption in the Act. It's in Section 16, called the Permitted General Situation Exemption.
Permitted general situation. Sounds broad.
It can be, but it has strict conditions. Kmart's argument hinged on the part of that exemption dealing with suspected unlawful activity. They said, We suspect unlawful activity refund fraud is happening or might happen.
Okay.
And, they argued, collecting and using this facial data through the FRT system is necessary for us to take appropriate action against that suspected fraud.
Necessary being the key word there.
Absolutely, because if something is truly necessary under certain parts of the Act, it can sometimes override the usual requirement to get explicit consent from the individual. That's what they were aiming for, justification, without needing individual consent for every scan.
But the OAIC didn't agree. They shut that argument down pretty firmly, didn't they? They found Kmart had unlawfully interfered with the privacy of potentially thousands of customers who hadn't done anything wrong.
Completely rejected it. And the core reason came down to the type of information being collected.
Back to the face print idea.
Exactly. The OAIC stated very clearly that biometric template derived from a facial image that's classified under the Act as sensitive information.
Okay, and sensitive information has special rules.
Much stricter rules. It's a specific subset of personal information, things like health data, political opinions, racial origin, and biometric data used for identification. Because misuse of this data can lead to serious harm like discrimination or identity theft, the threshold for collecting it is way higher.
So what's the threshold?
Generally, you need the individual's explicit informed consent before you collect sensitive information. There are very few exceptions. Kmart tried to use the necessary for suspected unlawful activity exemption, but the OAIC found that exemption couldn't apply here precisely because it was sensitive information. The Act basically prioritizes the protection of sensitive data over that particular exemption in these circumstances.
So the very nature of the data they chose to collect undermined their defense.
Pretty much. They couldn't rely on Section 16 to bypass consent for sensitive biometric data collection in this context. They needed explicit consent, and they absolutely did not have that from every customer walking up to the returns desk.
It feels like the commissioner also weighed up the sort of cost benefit here. Like, yes, fraud is a problem, but does it justify this level of privacy intrusion for everyone?
Definitely. That was a major part of the reasoning. The OAIC conducted what's essentially a proportionality assessment. They looked at the claimed benefit preventing some amount of refund fraud and weighed it against the privacy impact. Collecting sensitive biometric data from every single customer using the returns counter, most of whom are obviously innocent. The commissioner found that the system's utility in actually stopping fraud was somewhat limited, especially when you compare it to Kmart's overall turnover and the sheer scale of their customer base.
So the potential harm or intrusion on privacy massively outweighed the demonstrated benefit to Kmart.
That was the finding. The benefit just wasn't substantial enough to justify such a privacy-intrusive measure, especially when applied indiscriminately to everyone and without their explicit consent.
And did the OAIC suggest other ways Kmart could have tackled fraud? Ways that maybe didn't involve FRT?
They did, and this was quite telling. They pointed out several less privacy-invasive alternatives that Kmart could have considered or implemented.
Such as?
Well, some were technical, like using RFID tags, radio frequency identification on merchandise. These can help track if an item being returned was actually purchased without needing to scan faces.
Okay, that makes sense. Focus on the item, not the person.
Right. And some were operational, even simpler. They suggested Kmart could, for instance, just physically move the returns counter, maybe locate it near the store entrance exit, so someone doing a return doesn't even need to walk deep into the store, where the FRT might be more pervasive, or they could handle it without needing the same level of in-store surveillance.
Interesting. So basic store layout changes could have been an alternative.
Potentially, yes. The fact that these readily available, less intrusive options existed really hammered home the point that Kmart's FRT system wasn't truly necessary in the strict legal sense required by the Act. If there are other effective ways to achieve your goal with less impact on privacy, you generally have to use those first.
Okay, that failure to prove necessity seems central. But let's drill down into the specific breaches of the Australian privacy principles, the APPs. You mentioned Kmart failed on transparency. That relates to APP5, right? Notification of collection.
Yes, APP5 is all about telling people what you're collecting, why, and how. Kmart's efforts here were found to be seriously lacking.
What did they actually do to notify people?
They relied mainly on signage. They had a general conditions of entry notice somewhere near the store entrance, and also a separate privacy poster often displayed near the returns desk itself. These signs mentioned things like security measures might be in place, and sometimes provided a link to Kmart's general online privacy policy.
Which sounds okay, maybe, but not enough.
Not nearly enough, according to the OAIC. APP5 requires much more specific and clear notification at or before the time of collection. Just having a generic sign isn't sufficient, especially for sensitive information.
So what should they have told people, specifically?
Well, APP5 lists several key things. You need to inform people about the facts and circumstances of collection, meaning clearly stating, we are capturing your facial image and creating a biometric template.
Not just security cameras in use.
Definitely not. You need to state the specific purposes of collection. We are using this template to compare against a database of individuals suspected of fraud. You also need to explain the consequences for the individual if the information isn't collected, which in this case might be complex, but maybe relates to processing the refund.
Okay, and what else?
You also have to provide information about who you might disclose the information to, and importantly, how the individual can access their personal information or seek correction if it's wrong. And crucially, you need to link clearly to your APP1 privacy policy, which should contain even more detail. Kmart's signage and general policy just didn't provide this level of specific upfront detail about the FRT process.
So the core failure was not giving people enough clear, specific information before their face was scanned and turned into data, so they couldn't possibly give informed consent.
Precisely. Consent needs to be informed. If you don't tell people exactly what you're doing with their sensitive data, any consent you might try to imply, like them just walking past a sign, is essentially meaningless under the Act.
And that links directly to another failure under APP1, open and transparent management of personal information.
Yes, APP1 is about having clear and up-to-date practices and policies regarding how you manage personal information. It's the foundational principle for accountability.
So what was wrong with Kmart's privacy policy itself? They had one, right?
They did. OAIC actually looked at 3 different versions of Kmart's privacy policy that were in effect during the period the FRT was operating. All 3 were found wanting.
In what way?
The critical failing, which connects back to the notification issue, was the lack of transparency about the technical process involved. The policy didn't adequately explain. The commissioner used the phrase, even in generic terms, that collecting a facial image involved the creation of additional metadata.
That face print again.
Exactly. That biometric template is the sensitive information. By not clearly stating that this template was being generated, stored, and compared against a database, the policies were fundamentally misleading. They didn't give a true picture of the scope and nature of the personal and sensitive information handling that was actually occurring.
So true transparency under ATP1 means you have to explain the whole data journey, not just the initial collection. You can't just say, we use cameras.
Absolutely. It's the difference between saying, we have security cameras for safety, and saying, at this specific counter, we capture your facial image, convert your unique facial geometry into a mathematical representation, store that representation, and compare it against a watch list to decide if we'll serve you. Those are vastly different levels of information handling.
And APP1 requires that latter level of detail, especially when sensitive info is involved.
Yes, it requires clear, accessible language about what you collect, why, how you store it, how you use it, when you destroy it. The policy needs to be a practical guide for the public.
Okay, so big failures on notification and policy transparency. What are the actual consequences Kmart is facing now because of this ruling?
They're significant and binding. The OAIC issued formal declarations. Firstly, Kmart has to publish a statement on its website. This isn't just a quick apology. It needs to be a detailed explanation of its past use of FRT and acknowledge the OAIC's findings about the privacy breach.
When do they have to do that by?
The deadline is October 18th, 2025. And that statement has to stay publicly accessible on their website for a minimum of 12 months.
Okay, a public mea culpa. What else?
This is the big one, data destruction. The OAIC has mandated that Kmart must destroy all personal and sensitive information, meaning all those biometric templates that they collected via that specific FRT system.
All of it, from the entire period.
All of it collected through that system. And the deadline for destruction is very specific, exactly 12 months and 1 day after they publish that public statement.
Wow. So they can't even keep the data they might think helps with ongoing fraud prevention from that period. It all has to go.
Correct. It's a complete wipe mandated by the regulator. This reinforces the idea that if data was collected unlawfully, you lose the right to retain it.
This really underscores what the Privacy Commissioner, Carly Kind, said about these rulings, doesn't it?
It does. She was very clear in her commentary around this decision, and the earlier Bunnings one. She emphasized that the OAIC isn't banning facial recognition technology outright. The Privacy Act and the APPs are designed to be technology neutral.
So FRT isn't illegal per se.
No, not inherently. But as Commissioner Kine put it, using it, especially for collecting sensitive biometric data, involves clearing a high bar. You have to demonstrate genuine necessity, proportionality, transparency, and critically, you usually need explicit consent. Kmart failed to clear that bar.
It sets a very clear precedent then. If you're going to use tech like this, your justification and your processes have to be absolutely watertight.
Absolutely. The days of relying on vague notices or assumed consent for intrusive technologies are well and truly over in Australia.
Okay, so the Kmart case gives us a really sharp illustration of what happens when you fall foul of specific APPs, namely APP1 and APP5. But let's zoom out a bit now and look at the Australian Privacy Principles framework as a whole. It's more than just those two principles.
That's right. The APPs are really the engine room of the Privacy Act. There are 13 of them in total, and they govern the entire life cycle of personal information, how it's collected, used, stored, disclosed, and eventually destroyed.
How are they structured? Is there a logic to the 13?
There is. They're grouped into 5 parts in the Act. Part 1 is about considering privacy upfront. That's APP1 on open and transparent management, and APP2 on anonymity and pseudonymity.
Right, plan ahead.
Part 2 covers the collection of personal information. That includes APP3 on collecting solicited information, APP4 on dealing with unsolicited information you might receive, and APP5, which we discussed, on notification of collection.
Got it. Collection rules.
Part 3 then moves into dealing with personal information once you have it. This is a big section. It includes APP6 on the use or disclosure of personal information, APP7 on direct marketing, APC8 on cross-border disclosure, which is crucial, and APP9 on adopting government-related identifiers.
Use, sharing, marketing, overseas transfer. Okay.
Part 4 is about maintaining the integrity of personal information. That's APP10 on the quality of data, ensuring it's accurate and up-to-date, and APP11 on the security of personal information, protecting it from misuse or loss, and also covering its destruction or de-identification when no longer needed.
Quality and security. Makes sense.
And finally, Part 5 covers the access and correction rights of individuals. APP12 is about the right to access your own personal information held by an entity, and APP13 is the right to request correction of that information if it's wrong.
Access and correction. So it covers the whole journey from planning to collection, use, security, and individual rights.
Exactly. It's designed to be comprehensive, and as we mentioned, it's principles-based and technology-neutral.
What does principles-based actually mean in practice? Does it make things easier or harder?
Well, both, in a way. It means the APPs set out broad requirements rather than highly prescriptive, detailed rules for every single situation. Think, thou shalt manage data transparently, APP1, rather than thou shalt use 256-bit encryption for data at rest.
So it gives flexibility.
Yes, it allows the principles to apply across different industries, technologies, and contexts without needing constant updates for every new gadget or software. But the flip side is that it places a significant burden on the organization, the entity holding the data.
So,
because you have to interpret how those broad principles apply to your specific circumstances. You have to decide what's appropriate, what's necessary, what's secure in your context, and critically, you have to be able to justify those decisions if the OAIC comes knocking.
which brings us back to that phrase we heard in the Kmart case, reasonable steps. That seems to pop up everywhere in the APPs.
It absolutely does. It's arguably the most important recurring concept in the entire framework. You see it in APP 1.2, taking reasonable steps to implement practices. APP 8.1, reasonable steps before cross-border disclosure. APP 10.1 and 10.2, reasonable steps for data quality. APP 11.1, reasonable steps for data security. APP 11.2, reasonable steps for destruction. APP 12.5, reasonable steps to give access. APP 13.1, reasonable steps to correct. It's everywhere.
So what does it mean? Is it just what I think is reasonable?
No, definitely not subjective. The OAIC and courts have made it clear reasonable steps is an objective test.
Objective how?
It's judged based on what a hypothetical reasonable person who is properly informed about the situation and the risks would consider appropriate in the circumstances.
A reasonable, informed person.
Okay.
What factors does that person consider?
They'd look at things like the sensitivity of the personal information involved. More sensitive data like biometrics requires more robust steps. The potential adverse consequences for individuals if something goes wrong. A breach of health records is more serious than a breach of newsletter subscribers. The practicality, including the time and cost of taking certain steps, though cost alone is rarely a decisive excuse for doing nothing. and the size and resources of the entity, a large bank is expected to do more than a small local charity, though both must do something.
So it's context-dependent, but judged objectively.
Exactly. And because it's about steps plural, it implies an active, ongoing process. It's not a set-and-forget compliance task. You need to be constantly assessing risks, reviewing your measures, updating policies, training staff.
And documentation becomes critical here.
Absolutely crucial. You need to be able to demonstrate the reasonable steps you've taken. That means having documented risk assessments, clear policies and procedures, records of staff training, evidence of security testing, justification for data retention periods. If you can't show you're working, it's very hard to prove you took reasonable steps.
Right. You need the paper trail to back up your claim that your actions were objectively reasonable.
Precisely. Subjective belief that you're doing the right thing counts for very little if you can't substantiate it.
Okay, that clarifies reasonable steps.
Yeah.
Now, let's revisit the data definitions because the Kmart case really turned on this. Sensitive information, what else falls into that category besides biometrics?
It's a defined list in the Act. So besides biometric information used for verification or identification and biometric templates, it includes information or opinion about an individual's racial or ethnic origin, political opinions, membership of a political association, religious beliefs or affiliations, philosophical beliefs, membership of a professional or trade association, membership of a trade union, sexual orientation or practices, or criminal record. It also includes health information and genetic information.
That's a broad list. Health, politics, religion, union membership.
Yes, it covers areas where disclosure could lead to discrimination, prejudice, or other harm. That's why it gets that higher level of protection under the Act, primarily requiring explicit consent for collection and having tighter rules around its use, especially for things like direct marketing.
And this is distinct from the broader category of just personal information.
Correct. Sensitive information is a subset of personal information. The general definition of personal information is wider.
Remind us of that definition again.
It's defined as information or an opinion about an identified individual or an individual who is reasonably identifiable.
Identified or reasonably identifiable. Identified seems straightforward, name, address, phone number, but reasonably identifiable sounds fuzzier.
It is fuzzier, and deliberately so. It's meant to capture situations where you might not have someone's name directly linked to the data, but you could figure out who they are without too much effort.
Like putting pieces of a puzzle together.
Exactly. The test for reasonably identifiable is also objective. It asks, could a person, perhaps using other available information or resources, reasonably work out who this data relates to? It considers factors like the cost, difficulty, and practicality of re-identification.
Can you give another example, maybe in a digital context?
Sure. Think about, say, device IDs, IP addresses, or even detailed location tracking data from a smartphone app. On its own, an IP address might not identify John Smith. But if that IP address is consistently linked with other data points, maybe login times, website visits, purchase history associated with that IP, perhaps cross-referenced with publicly available information or data from other brokers, then the individual might become reasonably identifiable.
So data that seems anonymous in isolation might become personal information when combined with other data.
Absolutely. That's a key risk. And the OAIC's guidance is clear. If there's a possibility, even a moderate one, that an individual could be identified, you should err on the side of caution and treat the information as personal information, applying the APPs accordingly. Don't assume data is anonymous unless it's been properly and robustly de-identified.
Okay, that's critical. Now, let's move into how we handle data once collected.
Yeah.
APP 6 covers use and disclosure. What's the main rule there?
The fundamental rule of APP 6 is purpose limitation. You can generally only use or disclose personal information for the primary purpose for which you collected it.
The reason you told the person you were collecting it for, back under APP 5 notification.
Exactly. So if you collect someone's email address to send them a newsletter they subscribe to, that's the primary purpose, you generally can't then, say, sell that email address to a third-party marketing company without getting separate consent. That would be a secondary purpose.
Are there exceptions? Can you ever use data for a secondary purpose without fresh consent?
Yes, there are exceptions listed in APP 6. The most common one is if the secondary purpose is related to the primary purpose or directly related if it's sensitive information. And the individual would reasonably expect you to use or disclose their information for that secondary purpose.
Reasonably expect. Another objective test.
Yes. Would an ordinary person in that situation expect their data to be used in that secondary way? For example, if you collect a delivery address to send a parcel, primary purpose, the customer would reasonably expect you to disclose that address to the courier company, secondary purpose, directly related and expected. But they probably wouldn't reasonably expect you to use their address to send them unrelated catalogs from other businesses.
So it has to be connected and foreseeable.
Pretty much. Other exceptions involve things like legal requirements if a court orders disclosure, preventing serious threats to life or safety, or enforcement-related activities by authorities. But the default position is stick to the primary purpose or get consent for anything else unless a specific exception clearly applies.
Okay. And related to use is APP7, specifically about direct marketing. This must trip up a lot of businesses.
It certainly can. APP7 sets out quite specific rules. The first point is crucial. You generally cannot use or disclose sensitive information for direct marketing purposes at all unless you have the individual's explicit consent.
So no marketing based on health conditions or political views without asking first.
Definitely not without explicit opt-in consent. For non-sensitive personal information, the rules are a bit different. You can use it for direct marketing if the individual would reasonably expect it, or as you're marketing similar products to an existing customer, or if they consented, or if it's impracticable to get consent, but you meet certain conditions.
What are those conditions if you can't get consent?
In that case, you must provide a simple way for the person to opt out of receiving future marketing messages.
The unsubscribe link.
Yes, essentially. It has to be prominent, clear, and easy to use. And critically, it must be free, or at least very low cost. You can't charge people to stop receiving your marketing.
And you have to actually honor the opt-out request.
Absolutely. If someone opts out, you must stop sending them marketing communications within a reasonable time frame. Failure to do so is a breach of APP7. Also, if asked, you generally have to tell the individual where you got their information from.
So clear opt-out, honor requests, and no using sensitive data without consent. That's APP7.
In a nutshell, yes. It's about giving individuals control over how their data is used for commercial communications.
Now, let's tackle APP8. You flagged this earlier as critical, especially for businesses using overseas services. Cross-border disclosure.
Yes, APP8 is a major compliance headache and a huge area of risk. It deals with what happens when personal information flows out of Australia.
Okay. You mentioned a key distinction earlier, use versus disclosure. Can you elaborate on that in the context of APP8?
Sure. Let's say you're an Australian company, OSCO. If an employee within OSCO accesses customer data, that's generally considered a use. Even if that employee works in an OSCO branch office in, say, New Zealand, as long as OSCO retains overall control over how the data is handled according to its policies, it might still be considered a use within the entity.
So internal handling, even if geographically dispersed, can be used. What's disclosure then?
Disclosure happens when OSCO releases the personal information from its effective control to a separate entity located overseas. This could be a third-party service provider, like a cloud storage provider headquartered in the US, or a data processing center in India, or even a related but legally distinct subsidiary company overseas.
So sending it outside your direct control to another organization.
That's the key. Once it leaves your effective control and goes to another entity overseas, that's a disclosure that triggers APC8.
And why is triggering APP8 such a big deal? You mentioned the accountability trap.
Yes, this is Section 16C of the Privacy Act, and it's brutal. It states that if an Australian entity, the discloser, OSCO in our example, discloses personal information to an overseas recipient, and that overseas recipient does something that would breach the Australian privacy principles if they were bound by them, like having a data breach due to poor security or misusing the data.
Oh.
Then the Australian entity, OSCO, is deemed to have breached the APTs itself. You are held legally accountable and liable for the privacy failings of the overseas entity you sent the data to.
Wow. So if my U.S. cloud provider gets hacked because their security was bad, the OAIC can come after me, the Australian company.
Yes, that's the accountability principle, or the trap. You can't just wash your hands of the data once you send it offshore. You remain on the hook.
That seems incredibly risky. How on earth do businesses manage that? How do you avoid being liable for someone else's mistake?
You avoid it by taking reasonable steps before the disclosure happens. That's APP 8.1. You have to take reasonable steps to ensure the overseas recipient does not breach the APPs.
Okay, reasonable steps again. What does that mean in this context? What steps are considered reasonable for APP8?
There are generally two main ways to satisfy this. The first way is to be reasonably satisfied that the overseas recipient is subject to a law or a binding scheme in their own country that protects information in a way that is substantially similar to the Australian privacy principles.
Substantially similar law, like GDPR in Europe, maybe?
Possibly, but proving substantially similar is actually quite difficult. It's not just about having a privacy law. It needs comparable principles and effective mechanisms for individuals to enforce their rights. The list of countries deemed substantially similar by Australia is very, very short, so relying on this is uncommon.
Okay, so what's the more common way?
The more common way is through contract. You need to enter into a binding contractual arrangement with the overseas recipient that requires them to handle the personal information in accordance with the Australian privacy principles.
So you put the APP obligations into the contract?
Yes, but it's more than just a clause saying comply with the APPs. The contract needs teeth. It needs to specify clear obligations regarding data security, limitations on use, notification requirements in case of a breach, allowing for audits, data return, or destruction clauses. And crucially, the Australian entity needs to have actually done some due diligence to believe the overseas provider can and will comply with those contractual obligations.
Just getting them to sign isn't enough. You have to check them out.
Absolutely. You need to assess their security practices, their track record, their internal policies. Taking reasonable steps means doing your homework before you disclose. If you just sign a contract with anyone without checking, and they breach, you'll likely still be liable under Section 16C because you didn't take reasonable steps beforehand.
This sounds like a massive compliance burden for any company using cloud services or outsourcing.
It is. APP8 and Section 16C are arguably one of the biggest drivers for careful vendor selection and robust contract negotiation in the Australian privacy landscape. Get it wrong, and the liability lands right back on your doorstep.
Okay, let's move on to the integrity principles. APP10 is about the quality of personal information. What does that require?
APP10 requires an entity to take, guess what?
Reasonable steps.
Reasonable steps to ensure that the personal information it collects is accurate, up-to-date, and complete. That's APP 10.1. And APP 10.2 adds that you must take reasonable steps to ensure the information is relevant and accurate, up-to-date, and complete when you use or disclose it.
Accurate, up-to-date, complete, relevant. Why is this so important?
Well, think about the consequences of using inaccurate data. Making decisions based on wrong information, denying someone a service because their address is old, sending sensitive mail to the wrong place, making incorrect assumptions in profiling. Poor data quality can lead to real harm for individuals and poor outcomes for the business.
So how do you take reasonable steps for data quality?
It involves things like verifying information at the point of collection where possible, periodically checking in with individuals to update their details, like banks often do, having processes to correct data when you learn it's wrong, which links to APP 13, and importantly, not holding on to data for longer than necessary.
Holding old data increases the risk of it being inaccurate.
Exactly. If you're keeping customer records from 15 years ago that you never used, chances are high that information is out of date and inaccurate, which leads us directly to APP 11.
APP 11. Security of personal information. This feels like a big one too, especially with data breaches constantly in the news.
Huge. APP 11.1 requires an entity that holds personal information to take reasonable steps to protect it from misuse, interference, and loss, and from unauthorized access, modification, or disclosure.
Okay, protect it. What kind of steps are we talking about? Technical? Physical?
All of the above.
Yeah.
Reasonable steps for security depend heavily on the context, the sensitivity of the data, the potential harm, the entity's resources, but it generally includes a combination of measures.
Such as?
Technical measures like encryption, access controls, firewalls, intrusion detection systems, secure software development practices, physical security like locked cabinets, secure premises, controls over access to servers, and administrative or organizational measures like having clear security policies, staff training on data handling and phishing, incident response plans, regular audits, and strong password policies.
So it's a holistic approach.
It has to be. Security is only as strong as the weakest link. Having great firewalls doesn't help if an untrained employee clicks on a phishing link and gives away credentials.
Right. And APP 11 has a second part too, doesn't it? About getting rid of data.
Yes. APP 11.2. This is often called the destruction or de-identification obligation, or sometimes the housekeeping rule. It complements the security part.
What does it require?
It says that if an entity holds personal information and it no longer needs that information for any purpose for which it was permitted to be used or disclosed under the APPs, and it's not required by law or a court order to keep it, like under the Archives Act for Commonwealth records, then the entity must take reasonable steps to either destroy the information securely or ensure it is de-identified.
No longer needs it for any permitted purpose. That sounds quite final.
It is. The underlying logic is powerful. Data you don't hold cannot be breached. Data you don't hold cannot be misused. Data you don't hold cannot become inaccurate over time. It's a fundamental risk management principle, closely tied to the idea of data minimization.
So if the project is finished, the customer relationship ended, the legal retention period expired, you should actively get rid of the data.
Yes. You need processes for identifying data that's reached its end of life according to your retention schedule, which itself should be based on purpose, and then securely destroying it, shredding, secure wiping, or properly de-identifying it so individuals are no longer reasonably identifiable. Hoarding data indefinitely, just in case, is generally not compliant with APP 11.2.
Okay, that's a really important obligation. Now, let's touch on APP 2 again. Anonymity and pseudonymity. How does that fit in?
APP 2 is about giving individuals choice right at the start of an interaction. It requires that wherever it is lawful and practicable, individuals must have the option of not identifying themselves or of using a pseudonym when dealing with an entity.
So browsing a website, making a general inquiry, maybe leaving anonymous feedback.
Exactly. In those situations, forcing someone to provide their real name might be unlawful and is likely impracticable. However, the lawful and practicable limitation is key.
When would it not be practicable?
Obvious examples are things like needing to identify someone to deliver goods they've purchased, or to provide a service like opening a bank account where know your customer laws apply, or if you need their details to actually investigate a specific complaint they've made. In those cases, anonymity isn't practicable.
But the principle encourages designing systems to allow anonymity where possible.
Yes. It's linked to data minimization again. If you can provide a service or interaction effectively without collecting personal information, you reduce your compliance burden across all the other APPs. You don't need to worry about APP 5 notification, APP 6 use limits, APP 11 security for data you never collected in the first place. Strategically enabling anonymity is a smart privacy move.
Cool. And the final pair of principles are about individual rights, APP 12 access and APP 13 correction. What does APP 12 give people?
APP 12 gives individuals a general right to request access to the personal information that an entity holds about them.
So I can ask a company, what data do you have on me?
Essentially, yes. When you make a request, the entity must respond within a reasonable period, usually within 30 days, and must give you access in the manner you requested, if it's reasonable and practicable to do so. For example, provide copies, let you view it.
Are there reasons they can refuse access?
Yes. There's a list of exceptions in APP 12.3. They can refuse access if, for example, giving access would pose a serious threat to life or safety, unreasonably impact the privacy of others, prejudice legal proceedings or negotiations, reveal commercially sensitive information, or is unlawful.
But they have to justify their refusal.
Yes. If they refuse access, they must give you written reasons, unless unreasonable to do so, and explain the mechanisms available for you to complain about the refusal. They can't just ignore the request. And they generally can't charge you for making the request, though they can charge a reasonable fee for the administrative costs of actually providing access, like photocopying or staff time.
Okay, so a right to see your data. What about APP 13 correction?
APP 13 complements APP 12. It deals with ensuring the personal information held is accurate, up-to-date, complete, relevant, and not misleading, linking back to the quality requirement in APP 10.
How does it work?
2 ways. First, if an entity itself is satisfied that information it holds is inaccurate or outdated, etc., it must take reasonable steps to correct it. Second, if an individual requests the entity to correct their personal information, the entity must take reasonable steps to correct it if they agree it's wrong.
So if the entity doesn't agree the information is wrong.
If they refuse to make the correction requested by the individual, they again have to provide written reasons for the refusal, unless unreasonable, and explain the complaint mechanisms. Importantly, the individual can then ask the entity to associate a statement with the information, indicating that the individual believes the information is inaccurate, out of date, etc.
So even if they don't change the data, they have to attach a note saying, I disagree with it.
Yes. That statement must be visible to anyone who uses or accesses that disputed information. It ensures the individual's view is recorded alongside the entity's record.
So APPs 12 and 13 together give individuals significant power to see and control the accuracy of their information.
They do. They are fundamental rights underpinning the accountability framework.
Okay, that's a pretty comprehensive run-through of the 13 APPs. It's clear that compliance isn't simple and requires ongoing effort across the whole data lifecycle.
It really does. And as we're about to discuss, the bar is only going to get higher.
Right. So we've established the current framework under the Privacy Act. And the APPs is already pretty demanding, especially with interpretations like we saw in the Kmart case. But things aren't standing still, are they? There's significant legislative reform underway.
That's putting it mildly. There's major momentum for change driven by large-scale data breaches, evolving public expectations, and the need to keep pace with global standards like GDPR. We're talking about the most significant overhaul of Australian privacy law in decades.
And this is happening in stages, right? There was a first tranche of reforms that have already happened.
Correct. That first stage came through the Privacy Legislation Amendment, Enforcement and Other Measures Act 2022, which passed Parliament in late 2022 and took effect shortly after. Sometimes people refer to it as part of the PPOA bill discussions, but technically it's enacted law now.
Okay. The 2022 Enforcement Act. What were the key changes in that first wave? What's already different now compared to before late 2022?
The main focus of that act was, as the name suggests, on enforcement and boosting the powers of the regulator, the OAIC.
Giving the watchdog more teeth.
Exactly. The most headline-grabbing change was the massive increase in penalties for serious or repeated interferences with privacy.
We touched on this earlier. Remind us of the scale.
Before this act, the maximum penalty for a serious breach by a corporation was around $2.2 million. Peanuts for a large company. Now, the maximum penalty is the greater of three options. $50 million AUD.
$50 million.
Or 3 times the value of any benefit the company obtained, directly or indirectly, from the conduct constituting the breach.
So if you profited from misusing data, they can take 3 times that profit.
Potentially, yes. Or the third option, if the court can't determine the value of the benefit, 30% of the company's adjusted turnover during the relevant period, minimum 12 months.
30% of domestic turnover. That could be hundreds of millions, even billions for huge companies.
It could. It puts Australian penalties right up there with the toughest global regimes like GDPR. It makes privacy compliance a boardroom-level issue, an existential risk, not just a minor cost of doing business.
So dramatically higher penalties. What else did that 2022 Act do?
It significantly strengthened the extraterritorial reach of the Privacy Act. Previously, there was some ambiguity about whether foreign companies with minimal connections to Australia were covered. The Act clarified and arguably broadened the Australian link test.
How so? What's a test now?
It effectively removed the requirement that an overseas organization had to collect or hold personal information directly from sources within Australia to be caught. Now, if a foreign entity carries on business in Australia, even just online, targeting Australian consumers, they are likely subject to the Privacy Act regarding their handling of Australians' personal information, regardless of where they or the data are physically located.
So harder for overseas tech companies to argue the Act doesn't apply to them.
Much harder. If you're actively participating in the Australian market, you need to comply with Australian privacy law.
Okay. Higher penalties, broader reach. Any other key changes in that first tranche?
Yes. It also gave the OAIC enhanced powers. For example, stronger abilities to investigate breaches, share information with other regulators, domestic and international, and issue infringement notices for certain breaches without needing to go to court. It streamlined the OAIC's ability to act.
So overall, the first tranche was about making the existing rules bite harder and apply more broadly.
That's a good summary. It didn't fundamentally change the 13 Australian privacy principles themselves, but it massively increased the consequences of breaching them and strengthened the regulator's ability to enforce them.
Right, but the big structural changes to the APPs and the core concepts, those are still expected in the second tranche of reforms.
Exactly. The 2022 Act was Stage 1. Stage 2 is based on the extensive review of the Privacy Act conducted by the Attorney General's Department, which resulted in a final report with 116 reform proposals released in early 2023. The government agreed in principle with most of these.
116 proposals. That's huge.
It is. And the legislation to implement these core reforms is what everyone is anticipating, likely sometime in 2025, though the exact timing is always subject to parliamentary process. This is where the really fundamental shifts will happen.
Okay. What's the absolute headline change we expect to see in this second tranche? the one everyone's talking about.
Without doubt, it's the proposed introduction of a new overarching obligation for the handling of personal information to be fair and reasonable in the circumstances.
Fair and reasonable. We talked about this briefly. How does this actually differ from the current requirements, like APP3's rule that collection must be reasonably necessary for the entity's functions?
It's a significant conceptual shift. Reasonably necessary is often interpreted from the entity's perspective. Do I need this data for my legitimate business function? It's somewhat business-centric.
Right.
The proposed fair and reasonable test is intended to be much broader and more focused on the individual and societal expectations. It requires entities to look beyond just their own operational needs and ask, considering all the circumstances, is this collection, use, or disclosure objectively fair and reasonable from the perspective of the person the data is about?
So it introduces an ethical dimension, a balancing act.
Precisely. The explanatory material suggests the factors to consider would include whether the impact on privacy is proportionate to the benefit gained by the entity or the public, the reasonable expectations of the individual, whether the handling practice is deceptive or misleading, and whether it could have adverse consequences for the individual, especially vulnerable people.
Can you give a concrete example of how this might change things?
Let's take complex algorithms or AI used for profiling or decision-making. Currently, an entity might argue collecting vast amounts of data to train their AI is reasonably necessary for the function of developing that AI. Under fair and reasonable, they might also have to demonstrate that the way the AI makes decisions and its potential impacts, like bias leading to discriminatory outcomes, are fair and reasonable for the individuals affected. It forces a deeper consideration of the outcomes, not just the inputs.
So even if a collection is necessary for a function, it could still be deemed unfair or unreasonable in its impact.
That's the potential power of this proposed test. It acts as a backstop, overlaying all the other APPs. It raises the bar significantly, demanding a more ethical and justifiable approach to data handling, especially for practices that are particularly intrusive or opaque.
That sounds like it will require a big cultural shift for many organizations.
Absolutely. Documenting why something is necessary is one thing. Documenting why it's fair and reasonable requires a different kind of assessment, potentially involving genuine consideration of community attitudes and potential harms.
Okay, the fair and reasonable test is huge. What other major changes are anticipated in the second tranche?
Several other big ones. We expect to see tougher definitions for key terms, bringing Australia more into line with global standards like GDPR.
Which terms specifically?
Personal information itself might be brought into more clearly captured technical data like IP addresses or device identifiers, removing ambiguity. And crucially, the definition and requirements for consent are expected to be significantly strengthened.
Oh, so what would change about consent?
The reforms likely aim to make consent much more explicit, informed, voluntary, current, and specific, moving away from bundled consents hidden in long privacy policies or reliance on implied consent. You used our website, so you consented.
So more like ticking specific boxes for specific uses.
Yes, that's the direction. Consent would likely need to be much more granular. If you want to collect data for purpose A, use it for marketing, purpose B, and disclose it to third-party C, you might need separate, clear, opt-in consents for B and C obtained before those activities happen. The default would shift towards no unless someone actively says yes for each specific thing.
That would fundamentally change how many online services operate.
It would. It requires much more upfront transparency and user control. No more burying consent in the terms and conditions.
What else is expected in this big reform package?
There's likely to be a much stronger emphasis on accountability and privacy by design. This means entities will have more explicit obligations to proactively manage privacy risks, conduct privacy impact assessments, PIAs, for high-risk activities before they start, and be able to demonstrate their compliance measures are effective.
So building privacy in from the start, not bolting it on later.
Exactly. PIAs would become more commonplace, maybe even mandatory for certain types of projects involving new technologies or large-scale data handling. It's about forcing organizations to think about privacy implications during the design phase of products, services, and systems.
Any changes expected around individual rights, like access and correction?
Yes, the reforms are likely to strengthen those too. Things like potentially introducing a right to erasure, similar to GDPR's right to be forgotten, in certain circumstances, making it easier for individuals to demand deletion of their data. Also, potentially streamlining the access and correction request processes, possibly reducing timelines for response.
Okay. Tighter definitions, stronger consent, privacy by design, enhanced individual rights. What about that exemption we mentioned earlier, the one for small businesses?
Ah, yes, the small business exemption. This is probably the change that will affect the largest number of entities, even if the fair and reasonable test is conceptually bigger.
Remind us who is currently exempt.
Currently, businesses with an annual turnover of $3 million AUD or less are generally exempt from having to comply with the Privacy Act and the APPs unless they fall into specific categories like handling health information or trading in personal data.
So most small shops, cafes, tradies, consultants are currently outside the act.
Largely, yes. But the proposal in the Attorney General's review, which the government has agreed to in principle, is to remove this exemption.
Remove it completely.
That's the proposal. It means potentially hundreds of thousands of small businesses across Australia who currently don't have to worry about the APPs would suddenly be bound by the full suite of obligations, APP1 policies, APP5 notices, APP6 purpose limits, APP8 cross-border rules, APP11 security and destruction, APP1213 access correction, the whole lot. And they'd be subject to OAIC oversight and those massive penalties.
Wow. That's a tidal wave of new regulation for a huge part of the economy. Is that likely to happen overnight?
Probably not overnight. The government acknowledged the need for consultation on the best way to implement this, the timing, and what support and guidance small businesses would need to transition. So there might be a phase-in period or specific guidance tailored for small business, but the direction of travel is clear. The exemption is likely on the way out.
Why remove it? What's the justification?
The arguments are generally around creating a level playing field, ensuring consistent privacy protection for all Australians, regardless of the size of the business they're dealing with, and recognizing that even small businesses can hold sensitive data or suffer breaches with significant impact. Public expectation is also shifting. People expect their data to be protected wherever they provide it.
So small businesses need to start preparing now, even if the exact date isn't set.
Absolutely. Getting basic policies in place, understanding what data they hold and why, ensuring it's secure, thinking about consent for marketing, these are things they should start considering now because the change is almost certainly coming.
Okay. Taking all these expected reforms together, the fair and reasonable test, tougher definitions, stronger consent, privacy by design, removal of the small business exemption, it paints a picture of a dramatically different privacy landscape in Australia in the near future.
It really does. If these reforms pass largely as proposed, compliance post-2025 won't be about ticking a few boxes or having a dusty policy on the shelf. It will require a fundamental ongoing commitment to demonstrating ethical, justifiable, and transparent data handling deeply embedded in business processes.
It moves from a don't get caught mindset to a proactively demonstrate responsibility mindset.
I think that's a very good way to put it. The burden of proof will increasingly be on the organization to show they are handling data fairly and reasonably, not just legally minimally. Tag outro.
Right, we've covered a huge amount of ground today, from the specifics of the Kmart FRT case right through to the major reforms expected to reshape Australian privacy law. Let's try and distill the key takeaways for everyone listening. What are the core lessons here?
I think there are three main ones. First, what I'd call the Kmart lesson. If you're dealing with sensitive information, especially biometrics, health data, anything on that defined list, the bar is incredibly high. You need absolute clarity on necessity, genuine utility that outweighs the privacy intrusion, and almost always explicit, informed consent before collection. General notices or relying on broad business need just won't cut it anymore.
Okay, lesson one. High bar for sensitive data. Consent is king. What's the second?
Second is the framework lesson. Compliance with the current APPs and future ones demands continuous effort and objective justification. That phrase, reasonable steps, means you need robust documented processes for everything from your privacy policy, APP1, to how you notify, APP5, how you secure data, APP11, how you handle cross-border transfers, APP8 and its accountability trap, and how you destroy data when it's no longer needed, APP11.2. It's an ongoing operational requirement, not a one-off project.
Lesson two. Reasonable steps require constant work and proof.
Got it.
And the third?
The third is the reform lesson. The future of Australian privacy law is heading towards a significantly higher standard of accountability, driven by that overarching fair and reasonable test. This means thinking beyond just technical compliance. You need to proactively demonstrate that your data practices are ethically justifiable, proportionate, and truly respect individual privacy expectations, especially with consent becoming much stricter and the small business exemption likely disappearing.
Lesson three. Prepare for fair and reasonable. It's about ethical justification, not just legal minimums. Those seem like really solid takeaways.
They cover the key shifts, I think.
We saw in the Kmart case how a system designed presumably with good intentions to prevent fraud ended up breaching privacy law because of the way it collected and used sensitive metadata. It leads to a final thought, perhaps a strategic one, building on those principles around anonymity, APP2, and data destruction, APP 11.2.
Right. If the biggest risks come from holding and mishandling sensitive or identifiable data, what's the smartest move?
Well, it seems the most powerful strategic choice any organization can make, whether preparing for compliance now or especially for the post-reform world, is to adopt an intense, almost obsessive focus on data minimization.
Exactly. Don't just ask, how can we secure the data we collect? Ask, do we really need to collect this identifiable data in the first place?
If you actively design your systems, your products, your customer interactions to allow for anonymity or pseudonymity wherever possible, as APP2 encourages.
And if you are rigorous about implementing APP 11.2, proactively and securely destroying or de-identifying personal information the absolute moment you no longer have a legitimate, permitted purpose to keep it.
Then you fundamentally shrink your risk surface.
Yeah.
You reduce the amount of data that can be breached, misused, or become inaccurate. You lessen the burden of consent management, access requests, cross-border compliance.
The goal shifts. It's not just about building higher walls around your data fortress. It's about making the fortress as small as absolutely necessary. Hold less, risk less.
So perhaps the question for everyone listening is, how much personal information does your organization really need? And how quickly and effectively are you getting rid of it when that need expires? How does your current practice measure up against that objective standard of reasonable steps for minimization and destruction?
And looking ahead, how will those practices stand up to the test of being fair and reasonable in the eyes of your customers and the regulator?
Food for thought indeed. That brings us to the end of this deep dive. We hope this breakdown of the current landscape and the coming changes helps you navigate the complexities of Australian privacy law.
Thanks for joining us.